So I guess I just want to hear you say why you think that is. What justification is there for allowing greater flexibility here?
Well, I think one point is that there is a very wide range of sort of distribution of rural and urban, different kinds of areas, not just across the whole state, but within counties. And so delegating the decision-making with appropriate criteria to somebody who is local, which is what this is. These are local judges. In most of the state, they're judges. To make the relevant fact findings, to make the relevant inquiry. This is an interactive process in which these individuals and others are told, I'm not going to lift the restrictions now, but if you come back, if you have more to say about this, feel free to come back. It's an ongoing process. It's one reason why there isn't so much appellate litigation, is that that is what happens. So it's hard to see how you could specify everything in advance and have it be a clear on-off switch and still take adequate account of, on the one hand, the need for self-defense, and on the other hand, the strong public safety concerns. And that's why I think this system...
I don't think that was Justice Kagan's question.
Oh, I'm sorry.
It was on a broader level, I believe. She can correct me if I'm wrong. The issue is, no other constitutional right do we condition on permitting different jurisdictions to pass different regulations. But do we have any other constitutional right whose exercise in history has been as varied as gun possession and use?
Well, I think that's right, both at the local level, and at the state-to-state level. We have a strong history here of a range of responses from state to state that is based on local conditions and local concerns. And what we have within New York is an effort to recognize we have almost the same range of different kinds of spaces within the state, and this is the effort to accommodate that. And if the history warrants taking local conditions and local population density and so forth into account, it's hard to think of another way to effectively do that. There is, after all, appellate review available here, all the way to the central, to the highest state court.
Thank you, counsel. Justice Thomas, anything further?
But let's just take, for example, hunting. That's something I think we can agree on. You can't hunt, I'm sure, with a gun in Central Park. But I'm certain that there are places in upstate New York or even in western New York where you can.
Including Rensselaer County, yes.
Yeah. So I think what we're asking is if that you can have that difference for the purpose of hunting specifically, why can't you have a similar tailored approach for Second Amendment based upon if it's density in New York City, if that's a problem, the subway, then you have a different set of concerns in upstate New York.
Well, hunting permits work for particular locations, for particular areas, but it's all one statewide regime. I mean, and so too here, licenses are handled locally. It's not exactly the same, but it's the same model that licensing of handguns to carry a handgun for self-defense is handled locally under a single set of criteria, but with reference to local conditions. I think that's right.
Justice Breyer?
Are we considering here just the upper state New York law? We're not considering New York City, are we?
I don't see any reason to be considering New York City.
Okay, so it's not in the
petitioners
case.
Are not from.
They're not.
See,
okay,
yeah.
all right. Now, if you're trying to get uniformity, doesn't the First Amendment, isn't it filled with local statutes use the word may? parade permits, event permits. So
Yes.
it's not special. Can you think
Correct.
about
In the areas where permitting happens, which includes First Amendment areas, it could be parades, it could be solicitation for charity. There are various areas where First Amendment activity is
So
subject-
what I'm driving towards, and I thought also there is a brief here, I think it's the social scientists, remember the name of it, which says in instances where, and they do it statistically, they are more liberal in allowing people to carry concealed weapons who are good character people, and there is a greater risk of a crime or harm, where that happens, there are more deaths of innocent people. What is that brief? I'd about like to go back and look at the figures.
Yeah, I believe it is a brief of social scientists, but
All right, I'll find it.
Yeah.
But do you think it's useful to, were we to have a trial, could we go into that? I mean, I think the great problem would be, fine, let's have some absolute rules, uniform national rules. I'm not sure we have those in the First Amendment, but assume we do. What are they? What are those rules?
well, I think they would end up being factors that have to be taken into account because the range of situations is so different, both on the need side, on the public safety side. So I think it's very hard. In fact, that's one of the things that I think is hard about the suggestion that a sensitive place regime could replace a system like this.
Or if you had a guess on how many concealed carry licenses are given in the area under consideration, upstate New York or outside of New York City, in a given year or around, any way you want to put it, are they in the tens of thousands? Are they in
I can't do it statewide. I have statewide estimates, not estimates. I have permits for Rensselaer County and for statewide. It would be possible to get more, but we don't. I don't.
Are they rough? What are they?
This is in footnote 10 of our brief. In the 2-year period, 2018 to 2019, in the state, there were approximately 37,800 grants.
I get the idea. And if in fact it were remanded, I guess we could go into that in more depth.
That's correct. We have the grants. Of course, there are licenses that weren't granted in those years that are still valid, so that doesn't tell you how many licenses there are out there altogether. The thing we had to estimate was the grant rate because we don't have application data. We had to estimate that from other information, but we have the permits.
Justice Alito?
Is it correct that the non-speculative standard applies throughout the state? It applies equally in New York City and in the most rural location in upstate New York? Well,
it has been, the law has been interpreted to mean that, although the experience of granting licenses, or the experience with license applications, is that it is apparently more readily satisfied upstate.
So the individual officers have a degree of discretion?
Well, yes, they're asked, like judges on many issues, they are asked to take into account certain factors. They can be reversed if they took the wrong factors into account or if they failed to take the specified factors into account. It's not unguided discretion, but it is discretion in the sense that...
What guarantees, if any, are there in your regime that a licensing officer is not taking into account improper factors?
I mean, this is a question about the judicial system generally. If he correctly records the factors that he took into account, they write letters or opinions which may or may not fully disclose. One assumes will disclose what they thought was important. When they're not just the papers, but there are the, if he denies the license, he will say why. He has to say why.
We've been presented in your brief and all the other briefs in this case with an enormous amount of history, citations to all sorts of statutes and other sources. would you be willing to concede that maybe you got a little bit overly enthusiastic in your summary of some of the historical sources that you cited in your brief? I'm going to give you.
We did our best to be accurate in reporting what we reported. I don't know what you have in mind.
Yeah, well, I'm going to give you an example, which is, it's troubling. I can see how it would slip through. I'm not accusing you personally of anything. But on page 23, you say that in founding era America, legal reference guides advise local officials to, quote, arrest all such persons as in your sight shall ride or go armed. And this is a citation to John Haywood, a manual of the laws of North Carolina, 1814. So I looked at this manual, and what it actually says is, you shall arrest all such persons as in your sight shall ride or go armed offensively. And somehow that word offensively got dropped from your brief.
I would
think that's an irrelevant word.
I think it would have been better to put it in and make an explanation, but I do think it's an irrelevant word because we have substantial authority for the proposition that guns were deemed to be offensive weapons. And that's why we have this dispute about whether saying, there are different ways of putting it, offensively or with offensive weapons or to the terror of the people. These either describe a separate characterization, a separate feature that not all weapons have, that's my friend's position on this, or they describe the belief that all such weapons are offensive.
Well, I don't want to belabor the point, but of course if any possession of weapons outside the home was illegal, then there would be no need to put in the term offensively, the inclusion of that.
Well, there are many other weapons. Usually there's a list that's, it's not in this particular instruction, but there will be a list of weapons. They were talking about much more than guns, and it was guns that were said over and over again to be offensive.
All right, well, weapons. Thank you.
But that's the explanation.
Justice Sotomayor? Justice Kagan?
You started a thought and then you were taken off someplace else, so I just wanted to allow you to finish the thought. What you said was that there was a reason why a sensitive place regime cannot serve as a replacement, and then you were not given an opportunity to say why. So why?
Well, essentially because there are, it would be very hard in the first instance, and I think also not very acceptable in the to my adversaries in the second instance, to specify in advance all the places that ought properly to be understood as sensitive. So it sounds like a very convenient alternative. But for example, we were talking about Times Square on New Year's Eve. Times Square when the theater district, when commerce is in full swing, Times Square almost every night is shoulder to shoulder people. So then you end up having a very big difficulty in specifying what all the places are that have the characteristics that should make them sensitive. It has, in principle, it has an attractive quality to it, but in implementation, I think it would be unsuccessful.
Justice Gorsuch?
No further questions, thank you.
Justice Kavanaugh?
No, thank you.
Justice Barrett?
I have one. General Underwood, do you think Heller was rightly decided?
I think there is a lot of support historically and otherwise for it, so I'm quite content to treat it as rightly decided. I think there was an argument on the other side too, but that's true about maybe most of the difficult questions that come before this court. I have no quarrel with Heller.
Do you think that we are bound by the way that we characterized history in that opinion? Mr. Clement has pointed out that in some respects, the way that we treated, say, the Statute of Northampton and is different from the way that you argue that we should interpret that and the follow-on, statutes in the colonies. You argue that we should understand those in some other cases differently than we did in Heller. Are we free to do that?
I think you are, because I think the Heller decision made very clear that it was not deciding anything other than the right to keep arms in the home. In the course of arriving at that decision, it necessarily said a lot of other things that led to that decision, but I don't think they are controlling, or I think the opinion itself says we're not trying to do a full exegesis of the whole Second Amendment right, and there's more to be done, and it would be odd and really inconsistent with general practice to treat every sentence or every reference to a historical source as controlling for all time, as distinguished from for the purposes for which it was invoked.
Thank you, General.
Thank you, General. Mr. Fletcher?
Thank you, Mr. Chief Justice, and may it please the Court. New York's proper cause requirement is consistent with the Second Amendment because it is firmly grounded in our nation's history and tradition of gun regulation. Now, as Justice Alito said, there's a lot of history floating around this morning, and so I want to be clear that when I say that, I am putting to the side all of the disputed bits about the Statute of Northampton, about the surety laws, and I'm putting to the side laws that restricted concealed carry but did not restrict open carry. And I am focusing on laws that either prohibited or required a showing of good cause to carry a concealable weapon like a pistol. Tennessee enacted one of those laws in 1821. Texas followed in 1871. New Mexico and Arkansas likewise enacted such laws in the years immediately after the ratification of the 14th Amendment. And over the decades that followed, more than a dozen other states enacted other laws that were at least as restrictive as New York's. Like my friends from New York, I count about 20 laws in total that fit that description. Those laws remain in force in 7 states today, and more than 80 million Americans live under their protection. They are, in short, both traditional and common regulations. I'd welcome the Court's questions, or I'm happy to continue.
How do we determine which states we should look to? You focus a lot on Western states, but the West is different.
I agree, Justice Thomas, and I think there might be reason to be skeptical about a tradition that's only reflected in one state. I think that's a problem for Mr. Clement in relying on some of the cases exclusively from the antebellum South. But the cases that we're relying on come from the South, like the Tennessee, Arkansas, and Texas law I described. West Virginia had a similar law, as did Alabama, New York, Massachusetts, California, Hawaii. The tradition that I am drawing on spans 2 centuries, going back to the Tennessee law. It spans 150 years when you broaden it out to many states, and spans all regions, or virtually all regions of the country. So I think that's the sort of tradition that you can look to when defining a national tradition of gun regulation.
But, I mean, what is the appropriate analysis? I mean, we I think generally don't reinvent the wheel. I mean, the first thing I would look to in answering this question is not the Statute of Northampton, it's Heller. And Heller has gone through all this stuff, and obviously in a somewhat different context, although that's part of the debate. Self-defense at home, this is different, but I still think that you have to begin with Heller and its recognition that the Second Amendment, it has its own limitations, but it is to be interpreted the same way you'd interpret other provisions of the Constitution. And I wonder what your best answer is to the point that Mr. Clement makes in his brief, which is that, for example, if you're asserting a claim to confront the witnesses against you under the Constitution, you don't have to say, I've got a special reason. This is why I think it's important to my defense. The Constitution gives you that right, and if someone's going to take it away from you, they have to justify it. You don't have to say when you're looking for a permit to speak on a street corner or whatever that your speech is particularly important. So why do you have to show, in this case, convince somebody that you're entitled to exercise your Second Amendment right?
So let me start with the general question and then get to that specific point from Mr. Clement. As to the general question about Heller, we agree completely that the court ought to apply the method from Heller, which we, like I think all the parties, take to be look to the text, history, and tradition of the Second Amendment right. And we're applying that now to a somewhat different issue with the benefit of somewhat broader materials. Now, as to the question about why do you have to have a showing of need, I think the problem with Mr. Clement's formulation is that it assumes the conclusion. If you had a right, the Second Amendment conferred a right to carry around a weapon for possible self-defense just because an individual wants to have one available, then obviously you couldn't take away that right or make it contingent upon a discretionary determination. But the whole question is whether the Second Amendment right to keep and bear arms confers that right to have a pistol with you for self-defense, even absent a showing of demonstrated
I'm not sure that's right. I mean, you would, regardless of what the right is, it would be surprising to have it depend upon a permit system. You can say that the right is limited in a particular way, just as First Amendment rights are limited, but the idea that you need a license to exercise the right, I think, is unusual in the context of the Bill of Rights.
So I agree with that, but I think I heard even Mr. Clement in response to a question from Justice Kavanaugh say he doesn't have a quarrel with licensing regimes in general. And I think what that is one illustration of is that the Second Amendment has a distinct history and tradition, and that the way to be faithful to the Second Amendment is to be faithful to that history and tradition and not to draw analogies to other rights with their own histories and traditions.
Well, there's licensing and there's licensing. Maybe it's one thing to say you need to check, make sure you don't have a criminal record, make sure that all the other things you can check on, but not that we assume you don't have a right to exercise your. So I guess it's hard to say it without saying it. With exercise your right under the Second Amendment, and you've got to show us that you do.
So we would ask that question by looking to the history and tradition of the Second Amendment. And in Tennessee in 1821, you couldn't carry a pistol at all. In Texas in 1871, you had to have a showing of need if you were going to carry a pistol. And that showing of need was actually much less favorable than the New York regime. In Texas, in West Virginia, and in Alabama, in those laws that we cite, need to carry a firearm was a need that you had to show when you were prosecuted for violating the law. It was essentially a self-defense requirement, and you had to persuade a jury in a criminal trial that you had an immediate pressing need to be carrying the gun when you were carrying it. The laws, of which New York's is one, but by no means the only example, that began to become more prevalent in the 20th century, said, we're going to make that determination of need ex ante. We're going to require a showing of good cause. New York has done that for a century. I'm sorry, Justice Kavanaugh.
This might be a level of generality issue, but I think Mr. Clement responded to some of what you're saying on history and tradition by saying you have to look at carry laws more generally. And there was open carry traditions in a lot of those states. And so I think he followed up by saying, so open carry is one option, shall carry permit regimes for concealed carry another option, but what you can't have is no open carry and simply a may issue discretionary regime that will, in practice, he says, limit the right. So can you respond to that?
Yeah, I meant to be taking that into account in the account of history that I'm giving you. So the Tennessee laws refer specifically to carry publicly or privately. Texas, the same story. If I were here defending a regime that just prohibited concealed carry and allowed open carry, I would have many, many, many more states. But I'm focused on just this type of law, and even there, our submission is there's a substantial history and tradition of that kind of regulation. It's not the sort of outlier that the court confronted in Heller and McDonald.